Okay, we are almost online. We are almost live. We are live, I think. Now we are live. We are live. So we are live streaming.
Yes.
And I would like to hand over to Dr. Marotta to be able to initiate the proceedings of today.
Okay, thank you, Professor Milton. Good day, everyone. Good day, Professor Milton. Good day, Professor Shivati. Hi, everyone. Today we are going to discuss the pre-trial division of the International Criminal Court. In our panel of experts, we are going to have the presence of Professor Darkawat Rifati. He is from India. He's an international criminal law professor over 30 years of experience. From South Africa, we're going to have the presence of Dr. Ditaba Ransane. He's the director of the South African Government Legal Services. At the same time, Mr. Malacela Leso, he is the director of the International Relations from the Department of Justice from South Africa. Also, the presence of Mrs. Makwasa, she's an international law scholar, also from South Africa. At the same time, we are going to have the presence from Manrit Kaur. She's associate counsel at the ICC. Also, Professor Rama Gudumela. She's a professor of international criminal law, also from India. Also, we are going to have the companion of Professor Frimpong. Right now, he's based in Georgia, in the U.S., and Maria Mercedes Pisani and Alessandra Lanciotti from Italy. Both in the past, they were part of the Rome Conference delegate in 1998. And as always, the presence of our host, Professor Milton Award, director of the ICR Justice for Africa NGO. He's the founder, and he's also a professor of international criminal law and legal practitioner over more than 25 years of experience. Okay, Professor Milton, I pass the floor to you so we can start our meeting of today.
Thank you very much, Dr. Marotta. It's good to have you today. Dr. Marotta is an expert international counsel and is also director of international programs of IC Justice. It's nice to have Professor Dr. Sripathi Dwarakanath as well with us, a professor of international law, well accomplished in his area of research and teaching. And he's also director of international programs within the center. Ladies and gentlemen, viewers, wherever you are, world over, on all our platforms, we welcome you right now. I say good morning, wherever you are, good afternoon, good evening. And it's nice to have you again joining us on this live streaming to be able to attend and listen to the discourse that the professors, the very able professors that are before you today, will be discussing. That is, as indicated by Dr. Marotta, the pretrial chamber. The pretrial division, which has chambers, is a very critical organ of the International Criminal Court. And as will be seen from what the professors will provide to us, it's mainly governed by provisions under Part 5 of the International Criminal Court, the Rome Statutes, sorry. Basically articles running the whole way from the entire Part 5 up to Article 61, dealing with investigations from Article 53 down up to 61, dealing with investigations and prosecution. Is a very critical part of the process of prosecution or justice within the International Criminal Court, because it forms the threshold upon which prosecutions proceed or other proceedings are sanctioned within the Rome Statute system. Having said that, I would also want to indicate that we have other members of the panel who are supposed to join us. I've had information from Professor Dr. Gudumela Rama. She's attending a funeral arrangement, and hopefully she could be joining us late. I was in touch with the Professor the Emeritus, that is. He's traveling and is away from the United States. He just traveled to Ghana the other day. And I told him he needs the rest. He doesn't have to join us immediately after all those struggles in the United States. And I was also in touch with Council Brenda, the International Council, and she indicated she might be joining us. Otherwise, our viewers want to alert you that most of our proceedings will be undertaken during Saturdays when actually most of the panelists would be available. I was also in touch with Professor Dr. What's the name again? Pisani, Mercedes Pisani. Just the other day, she also expressed her interest to be able to join the panel. And we hope soon we'll have a full house of a panel of professors to be able to thrash out the topics that we present you. All right, for today, that I would want to hand over back to Dr. Marota to be able to conduct the rest of the proceedings from here. Thank you very much, professors, and thank you, viewers.
Thank
Over
you.
to you, Dr. Marota.
Thank you, Professor Milton. Also, today, the meeting that gathered us here is related to the pretrial chamber of the ICC. And it's very interesting because during this week, we have the preliminaries from the future judges that are going to be elected for the next, I think, 5 years. And they are going to be distributed. I mean, I don't know how many they are going, but this week that have passed was the first round. There were, I have the opportunity to watch some of them. They were very interesting. I mean,
they'll be going for the 9-year cycle because we have 9, 6, 3.
Yes.
Some of them are replacing others.
Yes, correct.
Right?
Yes, but they are very good professionals. I mean, anyone could have a seat in any of in the court. The ones that I think that for example, the guy Victor Silanis was one from Greece. Was a very good interview. He was very precise. I think that he will be a very good judge. Also, the Colombian.
He had very good recommendation from the committee.
And also the attorney from Colombia. He was a very sharp lawyer, and I think that also, for example, if I was the one that will decide which one could go to the ICC, for example, these two ones that I clicked very quickly during their interviews was that the guy from Colombia, you know, Colombia in the past 50 years, they have a very civil war against terrorism, and they have this they are very well trained lawyers related to human rights, fundamental rights related to due process. So I mean, he will be very useful. And on the other hand, from Victor, that he's a legal practitioner. He has his own law firm, and also to have the view from that part. You know, a judge from the street mart criminal defense, not from. Yeah, I mean, that's also. I mean, it's going to be very useful, and it's going to enrich the work of the ICC. So now that we are here related to the pre-trial chambers, I would like to start to do an introduction for all our viewers related to the importance of the pre-trial chamber. The pre-trial chamber, it's uh, in the common law for the U.S. That's more familiar for me. It's what is decided in a grand jury. It's when, in this case, the police, the FBI, the U.S. Marshal, they have the indictment, or also known as the criminal complaint. They have all the charges and all the counts, and you in the U.S. Dependent of the, how do you will say, the criminal code of each U.S. Of each U.S. state, or also known as the statutes of limitations in others. It will be decided if it's a grand jury or it's only a bench trial. But mostly it's a grand jury, and the grand jury, it will take a week, and they will decide it if this go to trial or not. In the civil law system, in the courts, in the legal system in the EU or in Latin America, that is more Romanic, Germanic, the pretrial chamber is also known, for example, in Spain or in Italy and in Latin America, it is well known as the judge or the court of investigations in some places, or the guarantee that is in Colombia and in Chile is known as the court of, uh, I have it here, of fundamental procedural guarantees. This is the judge. These judges will decide if uh, the prosecutor office and the defense and the criminal defense councils are doing their work according to the standards. So that's the core. How the pre-trial chamber for our audience works. It's the same. The pre-trial chambers will be like the referee that in every level of the investigations, according to the Rome Statute, um, the prosecuting office is doing the work, and at the same time, the defense have all the ammunition, for example, the quality of arms, nevis in idem, all that kind of rights that in this case the detainee or the guy or the person who is being investigated have all these warranties to show that he's having a, a very due process investigations, and after that the pre-trial chamber will decide if this goes to the next, if this goes to trial, or if it's that we have seen in the past of the jurisprudence of the ICC that it's not have merits for going forward for a trial. Uh, However, we need to see in this kind of procedures that sometimes there is some kind of passion related to human rights criminals, violators. Uh, so the pre-trial chamber, how I see it, needs to be like a medical surgeon. I mean, it needs to work by the clock, by the book, and to be very, very meticulous in how every evidence, how every witness testimony will be practiced in the court. Because this is the core. I mean, this is the core of how uh, the pretrial chambers, in my humble opinion, is the core of how in all around the world the courts of investigation needs to do their work. So I mean, it's a very important uh, how do you will say, a very important way, a very important path of legal work. So this will give the example for other countries how they need to do in other kind of crimes. It doesn't mean a human right violation. It could be a battery, it could be a robbery, but the pre-trial chamber, as I see it, and I encourage every hour of our viewers and our peers to have the opportunity to go to the rooms of the court of the ICC through the web to see um, how the pre-trial chambers do the direction of how a trial should be taken. So that's what I want to say in this introduction: the importance of the pre-trial chamber. And in other parts of the world, that they also have international human rights courts like the ICC. But for example, in Latin America, that we have the Inter-American Human Rights Court the Inter-American Human Rights Court. In the Latin American system, they don't have a pre-trial chamber. They will have the Inter-American Commission that works as a pre-trial chamber. So I think that if we go back, we're going to be like 70 years, so or less, or less 70 years that the Inter-American human rights systems began. They didn't know how to to emerge in this kind of international system. So they decided we will have a human right court. However, because it's related to states violations, we will have a commission that will work like a pre-trial chamber related to the investigations, because it was a state, it was not persons. But in the ICC we're different. We have for the ICC we have the since Nuremberg, the Nuremberg trials, the Nuremberg courts, until the ICC, we have these pre-trial chambers of investigation. So that's what I want to bring here. And now I will begin with the questions for our panelists. I will start for this very important question. The timing. Uh, do the timing that the pre-trial chambers that is not very the timing. How do you? It could be Professor Chipati or Professor Milton. Again, I would ask the question. What do you think about the timing uh, related to the investigation that takes sometimes place in the pre-trial chamber? Are you agree with the timing that the ICC have decided to take during uh, the amount of time that they take with all the limitation that they probably will have to do investigation in some country? For example, I bring this example, Venezuela right now. It passed the investigation. Our prosecutor Fatuda decided to open an investigation, and the pre-trial accepted to do the investigation of human rights violations against Venezuelan people by Maduro. Okay, it begins. So the timing is very important. How I ask this question because always the criminal defense attorney will challenge the timing. They will say, okay, we need a time. I mean, if we don't find I don't know, in a year, in 2 years, all this evidence, it should be declared a mistrial. However, we have the victims on the other side, and how the prosecutor office of the ICC have the elements to access to this evidence uh, in local. They will have to go to Venezuela, but it's under Maduro regime, so it's going to be very difficult to get that kind of evidence from there. So that's my first question. The question is, what do you think about the timing in the process during the investigations in the pre-trial chamber? You have the feeling that it depends on the situation. In one side, on the situation, I gave the example of Venezuela, because we need to. It's going to be very difficult to get in that evidence, and also have the right of the witness, the right of the victims. Or on the other hand, we have also is a person, even though he has committed international crimes, uh, the the perpetrator, but also he has rights. He has rights for timing, to his trial to have an end with all. He's also a human being. So my question here is the timing. How do you see it? How, in this check and balance of due process, um, warrant in this due process, fundamental rights, which one? Because I mean, it's a check and balance. The victims and the perpetrators both have rights, but how do you see this? Because always this is a discussion in every. I mean, both you are professors, and you know that this is a very critical discussion that always takes place. The timing for, in one side we have the victims that they need justice, and on the other hand we have the perpetrator that he also is a human being and he needs also justice. If he's going to be, if he's going to have a sentence, okay, this is the final ruling, but the timing, it cannot take 20 years for having a. I mean, this is absurd, to have a. Probably he dies in the he probably commits suicide, or he dies during the process. And the victim, what happened with the victim? The guy died, but the victims, if he dies, the process mistrial, it have an end. So how do you see this, Professor Shipati or Professor Milton? Professor, your.
Or even Brian is with us. Welcome, Brian.
Yes,
Can
Brian.
you hear us?
Yes, you are audible. Thank you very much.
Nice to see you. So you're welcome
Nice
to join the panel as well. So the question.
Yes, nice to see you, Prof. After a long time.
Thank you. Dr. Marota has just posed a question, and I hope you're welcome. Any of you, Professor Supathi, or even yourself, could attend to that. I'm also ready, but I would want to give you the chance first.
I missed a little bit of Dr. Marota's discourse, so I am in a state of confusion.
Okay.
I'll be glad if Dr. Marota can repeat this question.
Yes, okay, I will repeat the question. My question here is, we are in the pre-trial chamber with an indictment. Okay, we are going to investigate Maduro if he committed I gave the example of Venezuela, but here we have some very important issue that Maduro owns Venezuela. It's not like so. The timing for doing the investigation from the prosecutor office, the timing for having all the resources to show in court that Maduro has committed all these crimes against humanity in Venezuela. However, he controls all the institutions, so it's going to be very difficult in loco to do the investigations, because probably Mrs. Fatuda or any prosecutor office member is going to be very difficult to go to Venezuela. Probably he will probably be shot or kidnapped. I don't know. I'm giving this example. So the time that the pretrial chamber needs and the prosecutor office to build the case, and with the evidence, witnesses. However, there is a limit of time, because if this goes too far, we don't have justice for the victim, because probably the guy, the perpetrator, probably if he's old, he will die, or he will disappear. So the question is the timing related to due process, from your experience over these 30 years. How do you see this? The timing that right now the ICC through the prosecutor office and the pretrial chamber is correct for having at the end justice, or not? That's my question. Because remember, we have two human beings. I know that the perpetrator is a horrible, probably he's the devil personificated. However, what I have been taught that both, they need to have due process and do the investigation and do all related to going to trial. It's very important, and the timing is very important. If you can assure the timing is better for putting someone in jail after the process, and also for the victim, if you prolong this for the victim, it's very hard. So how do you see this, the timing of the pretrial chamber during the investigations for having a trial for the international perpetrator? How do you see it? The timing is good, it's not good? They could, I don't know, have many other resources for speeding it up. I give this example related to the European Court of Human Rights. The European Court of Human Rights, they decided to speed everything. They didn't wait to have any I don't know, any own, it was from in less than 24 hours, they decided to go online every case. At that point, the ICC was a little bit slow. So that's my
All right.
question.
Thank you, Dr. Marotta. I think to give Professor Sripati time to digest, I'll attempt to answer my part,
Yes.
just to allow him time. Thank you very much. That is a very critical question. I think it's a question that has generated considerable interest and concern among all practitioners at the international criminal justice level, and even those scholars who are involved or engaged in the study of international criminal law. This is my response to it. There are multiplicity of factors that would govern the duration or the timing, for that matter, of proceedings before court. First, we have to understand the stages through which any process that entails prosecution would undergo. Ordinarily, if there is a situation, depending on how the matter has come before the court, depending on the trigger mechanism that has been invoked, it would depend also on the geographical environment. Ordinarily, we would have a stage which is known as preliminary examination. This is a stage whereby the prosecutor takes time to be able to assess the situation on the ground in terms of evidence available, in terms of witnesses that are available in the areas that they are seeking to be able to administer justice, and a lot of other factors that are entailed within the prosecution process. So the preliminary examination in its own could take a long period depending on which case and which environment the investigations are taking place. I could, let me not use one yardstick for all the situations, because the circumstances obtaining in one given country may not be the same circumstances obtaining in a given situation in a different country or a different state party. We have a number of factors that may inhibit or slow down the process of examination and ultimately investigation. I'll come to the investigation part. We know, we've seen cases like instances where Donald Trump, who is on his way out, of course, as we know, from the United States, indicating that the International Criminal Court is just a kangaroo court and all that. So you can imagine where, like in the case of Afghanistan, which we discussed last time, which we debated, there have been a lot of frustrations on the part of orchestrated by superpowers like the United States, because apparently those investigations would touch on the American citizens. So the duration is a matter of, in my view, a question of factual interpretation, depending on the circumstances obtaining at any given time and in any given environment. It could be longer, but there's also motivation for trying to extend that investigation, the examination, to ensure that it is thorough. Because before the investigations per se proceed, the prosecutor has a statutory duty under the Rome Statute to be able to assess and marshal, elicit all the facts and evidence possible to present to the pretrial chamber. Because there are no investigations which will take place without the sanction of the pretrial chamber, as we're gonna see from this discussion today. So the prosecutor should be able to, during this preliminary investigation examination period, gather as much evidence as they could, get as many witnesses as they could to be able to convince the pretrial chamber that there is a case with a reasonable basis to proceed in terms of a particular crime against the suspects. So that could account for a duration in terms of that stage of the investigation, the examination. But again, as you indicated, there's been a lot of questions. You would ask whether would that be necessary? Would it be defeatist in terms of expediting justice in the ultimate analysis? That's debatable. It's left for anyone to be able to interpret. So when the prosecutor has been able to marshal all this evidence, they will then, and if they're satisfied in their own assessment that the evidence they have and the witnesses would be able to demonstrate that there is a reasonable basis for them to proceed with this matter before the International Criminal Court, then they would approach the pretrial chamber. They would approach the pretrial chamber and present this evidence, as we are going to see. That process, I may not go into it right now. I also have a lecture I gave, which I think I'll be able to share later. So the pretrial judge, it could be one or three, depending on how it's convened, would look at this evidence and decide whether there should be investigations proceeded and whether confirmation of charges can come through as well. So here, what we are talking about is the delay starts from the point of preliminary examination, and even during the process of confirmation of charges before the pretrial chamber, there are also anachronistic cobwebs that orchestrate a lot of delay within the process. And even after that, we have difficulties sometimes of tracing the witnesses and all those known complications that are entailed in the process of investigation. But it's a matter of concern, as you've raised it. It's very important that you've raised it. Everybody gets concerned as to how fast the justice wheel should be able to move to exude the process of justice in favor of the victims. We've had cases that have been languishing at the International Criminal Court for years, and no one knows when they'll be ultimately finalized. So in my view, a lot of factors could come into play, depending on which circumstances, the kind of case, the complexity of the cases themselves. The ICC cases are very complex. If you take the crimes against humanity, for instance, there are a number of other crimes under there. We have, if it's a crime of aggression as it is now, you would have to establish whether that particular state is actually has acceded to the other aspect of the crime of aggression under the Rome Statute before it can. There are a lot of technicalities involved. So in my view, the factors would depend on the circumstances, the kind of case, the environment, and the situation at the court, which has also backlogs. I hope now Professor Sripathi might be ready for his contribution on that part. That's all, professors, and thank you, Dr. Marota, for that question.
Thank you,
you
Professor Milton.
Yeah. Oh, okay, to Dr. Marota. Right.
Okay, thank you, Professor Milton.
Okay.
Now I pass the floor to Professor Srivati.
Now, thank you very much, Dr. Marotta and then Professor Milton. And I also greet and welcome all the viewers who are watching this program live. Now, with regard to the duration of time that may be taken for a prosecutor to commit a case before the pretrial chamber, as rightfully pointed out by Dr. Milton, uh, the main issue could be the collection of evidence. Because to commit a case before the court, the prosecutor needs prima facie evidence, and collection of evidence is the most difficult part, at least in cases before the International Criminal Court, because the evidence has to be collected from the state where the accused person is alleged to have committed. So even the witnesses, the statements of the witnesses have to be collected from that state. And therefore, it becomes necessary for the court to request the authorities in that state to cooperate with the court for collection of evidence and to follow other procedures, because the procedure of the court may be different from the procedure adopted by the criminal administration department of that state, because each country has their own ways and methods of investigating a crime. And therefore, it becomes necessary for the prosecutor to investigate a crime on the territory of a state where the accused is alleged to have committed a crime, to follow the procedures of that state. And the manner in which there could be difficulties for the local authorities in the investigation of a local crime in a state. Similarly, the prosecutor also could face the same difficulties in collection of evidence, in investigating a case, since the conditions on the territories of states are not the same. They vary from one country to another country. So again, as rightfully pointed out by Dr. Milton, we cannot have the same yardstick for every country. So it is very important to understand that we cannot fix a time limit for the completion of the investigation and then collection of evidence to commit a case before the court. And there could be other issues also, like generally in certain countries when a criminal trial is going on, we see that the witnesses become hostile witnesses, where the court is not in a position to do anything. So here also, if there is a confirmed witness in respect of a crime committed by the head of the state, and then at the time of investigation, if the witness is asked to give statements, he may become hostile and the prosecutor will be helpless to do anything. And even at the time of the proceedings before the pre-trial chamber, a witness can turn hostile. So these are some of the difficulties for not only the local courts in any country, and it could also be a difficulty for the International Criminal Court when the pre-trial chamber is trying a case. So this is my submission as far as the time taken for the completion of investigation and committing a case for trial before the National Criminal Court.
Thank you, Professor Sripati, for sharing us your thoughts and your knowledge. on this. I was, for example, I was reading the Criminal Procedure Code of Peru related to what we're gathering us here. That is called in Spanish is la investigación preparatoria. That means the preliminary investigations. So according to Article 334, and this code is up. I mean, this code was updated in 2004, and in Peru it changed because it was more like before that the criminal investigations in Peru was more like an inquisition, um, and they changed it. Yeah, it was very, I mean, it was like like in Spain in all time. So, but they changed it in 2004, and now this code is they began with corruption cases, and then they pass it and they started in every part of they divided. In 2004, it started in two provinces in Peru, and now it's all around the country. So, because you need to prepare the judges, you need to prepare the prosecutors, because it's more like an adversarial, like in the U.S. Without a jury, because it's more civil law. But here I was checking the article 334 that it says, and what says it's the time that the prosecutor has to do for a minimum of time for any crime is 65 days. However, it says that the, the prosecutor can ask for more time if it's a complex case. And and I was checking that there is from the there is a ruling from the constitutional from the constitutional court in Peru, that it says that it can take, depending if it's related to human rights violations or crimes against humanity, the prosecutor have the time of 36 months for the investigation to gather. Because in the past, analyzing what happened in Peru against the war against two terrorist groups that they had here, it was MRTA and the Shining Path. uh, it was very difficult at that time to gather even in Peru, it was because it was a war inside. Also in Colombia, it was very difficult to gather the information and all the evidence. So in a ruling, this ruling is back 20 years ago. The constitutional court that is it's like in the EU, it's like in the European Union. Here in Peru, they have a constitutional court that is over the Supreme Court related to any constitutional fundamental right. They decided that, okay, I mean, it's your constitutional right to have a time of investigation or a time. However, if it's are cases that are crimes against humanity, torture, anyone, the prosecutor office has the time of 36 months for doing the preliminary investigation, and that was very because they try to they put in every kind of situation. If the country is under a dictatorship, under a dictator, or any other kind of situation, try to give the elements. And and the time, okay, if you are in the worst case scenario, you have 36 months, and in 36 months you have to prove the guy you are investigating committed all these atrocities. But it's a start. And as Professor Milton told us, that in an international level, it's much sometimes it's much difficult, because every case, and in every country, we need to understand the cosmobiology and the situations, and how sometimes, if the prosecutor office of that country will help the prosecutor office of the ICC, sometimes, even though there is the international cooperation, laws by also country A have a treaty with the ICC related to international cooperation, but we don't know if the ones that are going to be investigated have a relationship directly with the government and they can pull the strings so they can put on hold the investigation and the aid of the prosecutor office in that country. So yes, it's a very sometimes it depends. It depends a lot. As I remember, uh, in my master's, a teacher told us that
Sorry,
the
can we welcome Professor Dr.
Professor
Ramos?
Ramada.
Sorry, Dr. Marota.
No problem.
Yeah, it's good to see
Thank
you,
you,
Prof.
Professor. Thank you, Professor Milton. How are you doing?
We're okay. How are you doing? Nice to see you. I
I'm
told the
good.
panelists that you might not show up, but you are dedicated.
Yeah. That's the reason I joined little late 1 hour. We went to it is 40 kilometers away from my home. So
Oh,
yeah, so traveling and all I calculated. So it took 1 hour and I joined.
a true professor.
Thank you, Professor. Thank you.
Okay.
Good evening, Dr. Marota. How are you doing? Good.
Fine,
Nice.
thank you. Thank you
Nice
for
to
joining us.
be again in the panel. Good evening, sir. Dwarkanath, sir. Good evening, my dear teacher.
Good evening. How are you?
Good, sir. Good, sir. Thank you. And good evening, Mr. Brian. I'm so sorry to interrupt like this, and I just wanted to wish you all one. Yeah. Please
Hello,
continue.
how are you?
I'm good. Thank you.
I think we are now many, so we should limit time so that everybody gets
Yes,
it.
yes.
So
I just
we'll offer it to the rest of the professors.
summing up.
Proceed.
That's the point.
Yeah.
That we see that sometimes in some countries, I put the example of Peru because I have at hand the new criminal code of procedures. So that's the most important thing that we need to understand is the timing not depends on how the ICC pre-trial chambers with the prosecutor office do the work. It depends on the country when they are going to do investigations and how they are willing to help or not, depending on the situation, to the ICC. So that's so what I want to also to show here is that the international criminal law have more of national law than international law because it depends in local uh, of how they will be aid with investigation, with witness protection, testimony, and all to gather information to take someone to international justice. Okay, so so we'll continue with our panel related to the pre-trial chamber. So the next question that I want to ask to the panels, I have it here. One moment, please.
Dr. Marota, don't you think
Yes.
we have the professors present, then later we
Yes, of course. Yeah, yes, that's the
go
idea.
into
Okay.
general
Yes.
discussion. So that
Yes.
we're not
Okay.
wasting
I pass the floor to
we have already gone up to 4. We are left with
Yes.
30 minutes left.
Yes, of course.
So
Yes, I pass
have the professors.
I pass the floor to you, Professor Milton.
Any of them could.
Oh yes, okay. Yes, so
If
I
Professor
will pass the
you are
floor
ready?
to Professor Shipati. If
Oh,
he
you are
wants to-
done.
No. Give them chance because we are running out of time. Let them speak and then I'll add.
Okay.
Okay, we can have Dr. Rama.
Yes, Dr. Rama.
If you have ready.
Hello, professors. Hello, everyone. A very good evening. Actually, I'm the pre-trial chamber of ICC. Even I mean, like I didn't dwell any time into research on this topic, but as I have seen, it's one of the presidency chamber of ICC, which deals with the process of first of all to decide as to whether this case is falling under the jurisdiction of ICC or no. The pre-trial chamber plays an important role, and of course there are 3 judges here, in the pre-trial chamber to decide on whether the investigation process should be carried out, or that is the leave which is granted by the ICC pre-trial chamber allows the investigation process to take on. So this is, I think, the first. Not I think. I mean, like, I'm sure that this is the first stage of the trial procedure against an individual, whether he is going to come under the jurisdiction of ICC or no. And this is what I have an idea. And as to what are the research questions on this, I would like to know from the panel, like where is the lacuna, or how we have to go about it, the research oriented point. I just would like to know from the experts.
Thank you, Prof. Now we can have
Thank you.
Professor Sripathi. I will come last because I have a lecture I want to share. There's a lecture which might
Yes.
not
Now, coming to the role of the pretrial chamber, Article 56 of the Rome Statute deals with the role of the pretrial chamber, and as pointed out by my student and research scholar, Dr. Rama, the pretrial chamber plays a very important role, particularly in cases where there's a unique investigative opportunity. That is where the prosecutor considers an investigation to present a unique opportunity to take testimony or a statement from a witness, or to examine or test evidence which may not be available subsequently for the purposes of the trial. The prosecutor shall inform the pretrial chamber. And once the pretrial chamber is informed by the prosecutor, the pretrial chamber shall take measures that are necessary to ensure the efficiency and integrity of the proceedings, and also to protect the rights of the defense. Unless the pretrial chamber orders otherwise, the prosecutor shall provide the relevant information to the person who has been arrested or appeared in response to a summons in connection with the investigation referred, in order that he or she may be heard on that matter. Now, this is a common provision in the local criminal laws of all countries, that when a person is arrested, he needs to be informed of the charges that have been made against him before his arrest. So the same procedure is being followed by the ICC, and that is the pretrial chamber. So this is where the pretrial chamber plays an important role, and the measures that the pretrial chamber takes in order to protect the defense is, firstly, making recommendations or orders regarding procedures to be followed, because the the RPA is very much there as far as the excuse me for the
Okay. I just wanted to say we want to thank
I have a little
Rama,
roughness in my throat.
very nice summary she made. Sorry, I skipped you before thanking her. That was brilliant.
Thank you.
Within a short time, we covered the whole topic. All right, I hope now you're right. Okay.
So the other measures that the pretrial chamber takes is to direct a record to be made of the proceedings, so that the proceedings will be there for future reference. Then, if need arises, to appoint an expert to assist, and then authorizing a counsel for a person who has been arrested or appeared before the court in response to a summons. That is where, if the accused person does not have a counsel to defend him, then at least in India, the Criminal Procedure Code that lays down the procedural laws for administration of criminal justice, if an accused person is financially not sound to afford a legal practitioner of his choice, in fact, he cannot afford a counsel at all, then it is the state that shall appoint a counsel for the accused person, because it is only to ensure a fair trial. Because in India, the courts, the criminal courts follow the adversarial system of a criminal trial. That is, you have the prosecutor on one side and the defense counsel on the other side. So if the accused does not have a counsel, then it would be an unfair trial. So in order to ensure a fair trial, the state appoints a counsel for the accused, and he shall act as the defense counsel. So here also, the pre-trial chamber shall appoint a counsel for a person who has been arrested. And such an arrest or appearance or counsel where it is not designated, appointing another counsel to attend and represent the interests of the defense. So where if the designated counsel does not appear, then immediately another counsel is appointed by the pre-trial chamber so that the pre-trial chamber continues in a fair manner. Then taking such other action that is necessary to collect or preserve evidence. This is also a measure that is taken by the pre-trial chamber, and where the prosecutor has not sought measures pursuant to Article 57, but the pre-trial chamber considers that such measures are required to preserve evidence that it deems fit. Now, a decision of the pre-trial chamber to act on its own initiative under this paragraph may be appealed by the prosecutor. The appeal shall be heard on an expedited basis, that is, in an urgent manner. Now, apart from these powers that the pre-trial chamber exercises, the Article 57 also lays down functions and powers of the pre-trial chamber. Now, according to Article 57, orders or rulings of the pre-trial chamber issued must be concurred by a majority of its judges. That is, there should be a majority of the judges and they should concur in respect of any order or ruling that is passed by the pre-trial chamber or issued by the pre-trial chamber. Now, this is necessary at least in cases which fall under Articles 15, 18, 19, 54, 61, and 72. Now, in all other cases, a single judge of the pre-trial chamber may exercise the functions provided for in this statute, unless otherwise provided for the rules of procedure and evidence or by a majority of the pre-trial chamber. So, this is also an important function that is performed by the pre-trial chamber, and in addition to these functions, there are certain other functions under the statute that the pre-trial chamber may perform. One is, at the request of the prosecutor, the pre-trial chamber shall issue such orders and warrants as may be required for the purpose of an investigation. So we have seen in all the discourses earlier that the prosecutor has been referring cases for permission. That is, he needs authorization from the pre-trial chamber before he starts an investigation. So this is where the pre-trial chamber plays an important role by issuing an order and authorizing the prosecutor to start an investigation. But for this, the prosecutor has to convince the pre-trial chamber with all the evidence. Only when the pre-trial chamber is convinced, it shall order or authorize the prosecutor to start an investigation. Now, upon the request of a person who has been arrested or has appeared pursuant to a summons under Article 58, the pre-trial chamber shall issue such orders, and that includes measures such as those described in Article 56, which I mentioned, or seek such cooperation pursuant to Part 9 as may be necessary to assess the person in the preparation of his or her defense. Now, the pre-trial chamber also authorizes the prosecutor to take specific investigative steps within the territory of a state party without having secured the cooperation of that state under Part 9. This is what I spoke of in my first earlier discourse, because the procedure adopted by the countries may vary from another country. So it becomes that much more difficult for the prosecutor to collect evidence. So this is where the prosecutor authorizes, the pretrial chamber authorizes the prosecutor to take specific investigative steps within the territory of a state party without having secured the cooperation of that state under Part 9. If, whenever possible, having regard to the views of the state concerned. So it is very necessary that the prosecutor should seek the cooperation of the criminal justice authorities in a country before he proceeds with the investigation. The pretrial chamber has determined that the state is clearly unable to execute. That is, in any case, if the state is unable to execute a request for cooperation due to the unavailability of any authority or any component of its judicial system competent to execute the request for cooperation under Part 9. So sometimes when the prosecutor makes a request to the authorities in a state where the investigation is to be made, and if the state is clearly unable to execute the request of the prosecutor because of reasons such as unavailability of any authority in that country or any component of its judicial system which is competent to execute the request for cooperation under Part 9. So this is where the prosecutor shall authorize a specific investigative step. Now, where in other cases a warrant of arrest or a summons has been issued and having due regard to the strength of the evidence and the rights of the parties concerned as provided for in the statute and the rules of procedure and evidence, seek the cooperation of states pursuant to Article 93, paragraph 1K, to take protective measures for the purpose of forfeiture, in particular for the ultimate benefit of the victims. So this is also something that the pretrial chamber lays down to protect the rights of the victims in order, that is to take protective measures for the purpose of forfeiture. So these are some of the important functions that are performed by the pretrial chamber, and that is why the pretrial chamber is considered to be one of the most important organs of the International Criminal Court. So I suppose that answers the question posed by my research scholar, Dr. Rama. Are you satisfied?
Yes, sir. Yes, sir. Little. I mean, I just had few doubts, like Professor Milton. I want you to, continue this so that I can be clear of more aspects.
Yeah,
Because
yeah. Not a
whatever
problem.
whatever sir has said, it's quite clear. Just a little bit addition from your side that would give a clear picture, I think. Yeah.
But your presentation just within a short time, I was surprised it covers the whole horizon. That was brilliant. All right, thank you very much. Brian, do you have something? Because I want to get into my presentation, unless you want to come afterwards, after listening to mine.
Thank you very much. I just have a question. The question that I have is if there are any limitations on the pre-trial chamber, if any. Thank you.
All right, thank you. I think my presentation will address some of the limitations, as well as what Professor Sripathi and Professor Dr. Rama have just summarized. The number of limitations there, including the question that Dr. Marota put across. Actually, that question was very important because it almost covered the essence of the pretrial chamber and the operations of the International Criminal Court as a whole. But now, thank you for that. I would like to make a presentation with your permission, Dr. Marota.
Yes, Professor, you have the floor.
Thank you,
Proceed.
Doctor. Thank you very much. Thank you, Dr. Marota. Thank you, Professor Dr. Rama. Thank you, Professor Dr. Sripathi, and thank you, Councillor Brian Ramapani. It's a pleasure to have you on board, and thank you all the viewers who are online, who are listening to us. I would like to address the issue of the pretrial chamber division. There is the pretrial division and pretrial chamber. I would like to make a distinction here. It's commonly used interchangeably as if they mean one and the same thing, but not necessarily. So when we talk about division, we have three divisions within the International Criminal Court. We have the appeal division, we have the trial division, and then we have the pretrial division. Within the division, each of the divisions have chambers. They can constitute chambers to be able to attend to cases. It's like the pretrial chamber ordinarily has about 3 chambers.
1, 2, and 3.
Pretrial division, sorry. Yeah, pretrial division has 3 chambers within it. It has been constituted depending on which case comes over. The president of that division may be able to assign particular judges to a particular chamber. And ordinarily, you'd see that the significance of assigning 3 judges is to ensure that there's an odd number, and therefore when voting comes or if a decision is made, there's a majority decision. But there are instances where one judge could be assigned to a particular chamber, to one chamber to deal with a particular matter. So that's the starting point. Within the pretrial division, we have pretrial chambers attending to various things, and which could be presided either by 3 judges or 1 judge. Okay, having said that, ordinarily the pretrial chamber is the gateway into the Rome system of justice in terms of litigation. As we said in retrospect, before any investigations can be conducted by the prosecutor, there must be a sanction by the pretrial chamber or the pretrial division. The pretrial judges must sanction whatever investigations are to take place, either through proprio motu, that is at the instance of the prosecutor himself or herself, or whether it's referred to by the Security Council, still it has to go through the pretrial chamber, or if it's the referral from the state. So we find that the pretrial chamber is a busy workshop that looks at a lot of other things before any proceedings are advanced within the system. That includes looking into the admissibility of matters or just whether there's jurisdictional matters. If there are challenges relating to jurisdiction and admissibility of a case before the International Criminal Court, this is where it starts from. And to answer even what Dr. Marotta had put across, why there are delays and time factor, is because the prosecutor seeks under the preliminary examination. There's preliminary examination before the investigation. The prosecutor undertakes the preliminary examination like we saw in the case of Afghanistan, which we discussed some weeks back, so that they could gather as much evidence as possible to present and convince the pretrial judge or judges that they have reasonable grounds to proceed. They have sufficient evidence to be able to proceed with the matter. And another critical point, there is no warrant of arrest or summons to appear which can ever be valid and issued unless it has been issued by the pretrial chamber or the pretrial judges. That the prosecutor who is armed with a warrant only does so after seeking the approval of the pretrial chamber, perhaps summoning the witness, the accused or any other party to court. Okay, with that said in the background, I want to invite you, I want to share a lecture which I gave on the aspects of pretrial chamber and trial, but I'll only show the part of the pretrial chamber. It would discuss, it's a very brief part that will cover most of the points that I would want to raise. So with your permission, I'm going to share this right now so that we see what we can have. Thank you. Topics. So these lectures are critical. They take into account
all those interests. All right. So we're going to look at what happens.
Can you hear?
After the accused has been.
Yes, yes, we can hear.
You can see?
The international.
Yes.
And his invitation. The first thing is to have the prosecutor will ensure the accused is arraigned before the pretrial judge at the moment. And we know that the pretrial chamber deals with the initial preliminary stages. It's not a trial, it's a preparation for a trial to see whether the trial should proceed or not. So there'll be confirmation of charges before the trial itself takes place. The confirmation of charges takes under the process of confirmation of charges is undertaken at the pretrial chamber. We did indicate that within the apex, within the hierarchy of the chambers, we have the appeal chamber, which is presided over by the president of the Court of Appeal of the International Criminal Court and other 4 appellate judges. There are a total of 5 at the appellate level. Then we have the trial chambers at a hierarchically lower level. This is convened usually by the president of the International Criminal Court once the pretrial chamber has certified that the trial should proceed. And we have the pretrial chamber that deals with the preliminaries, oversees what the prosecutor does in terms of what comes before the court as a check, as we said, irrespective of the independence of the prosecutor of the International Criminal Court to be able to pursue matters independently. All right, so we said that the suspect will now be brought before the pretrial chamber. Why? Why do we want the suspect before the pretrial chamber? One critical point is to identify and confirm in a formal manner that the person before the court is the one identified and suspected, who is the suspect in the course of those crime activities, actions, or omissions or conduct. So the appearance of this particular individual before the pretrial chamber is meant to establish that we have the right person, we have our man before the court. This is critical because once the identity has been established, it is critical that he, as part of his rights, even under domestic circumstances, his constitutional right, human rights internationally, he should be able to know what he is charged with. So in other words, it's critical to comprehend the substance and extent of the charges that have been brought and laid before court against that person. So the chamber, that's the judges in the pretrial chamber, would satisfy themselves that the charges, the accused person, the suspect, comprehends the charges and comprehends them clearly. That would mean the implication or whatever comes as a corollary here is that the language issue steps in. So they'll ensure that this is explained in a language that is best understood by the suspect before the trial chamber. Okay, once all these have been established and the court is satisfied that the chamber is satisfied that the suspect has been able to comprehend the nature of the charge and that this is actually the person they are looking for, then the next thing is to be able to set the date for those hearings for arguments in respect of the pretrial chamber. And mark you, this is not a date for trial, but it is the date for purposes of confirming charges, what we call confirmation of charges against the accused. And remember, as we said, the accused has rights, the suspect has rights, and these rights are very critical. I think I should take 1 minute or so outlining the rights of the accused in this account. One, we said, there's a presumption of innocence, which is a universally accepted principle, generally speaking, that whoever is accused is innocent until proven in a criminal case beyond reasonable doubt that they are guilty. So that is very, very critical, and it is the onus lies, the onus of the burden of proving or establishing beyond reasonable doubt rests upon the prosecution, not upon the accused person. So it's the duty of the prosecution of the International Criminal Court at this stage to prove the guilt or otherwise the guilt of the accused. It's up to the judges to establish on the basis of the evidence and the testimonies whether or not the accused is guilty or not guilty. And there, if guilty, then the process goes, as we shall see, conviction or any other sentence that will come. And remember, this proof has to be beyond reasonable doubt, not on the balance of probabilities, as would be the case under the civil proceedings. What are these rights? Okay. First, these trials before the ICC in general, by and large, proceed in public. The suspect is entitled to a public hearing of the trial of the matter, unless the judges decide that there are sensitive issues or matters which would be prejudicial, so that the matter will proceed in camera. But that must be clearly explained and understood. And the accused also has the right to make representations by themselves or through their lawyers. Given the complexity of international criminal procedure or criminal law at this level, it is always critical that an accused person would have representation, legal representation of their own choice, and that is a right. In the event that they're impecunious or they're pecuniarily challenged, then the court to proceed upon the premise that such a person deserves to have, unless otherwise they dissent, they deserve to have legal representation provided free of charge, so that they know their rights and they get acquainted with the procedure. Those representatives would be able to take care of their interests. So now, what right does the accused have apart from just public hearing? So those trials should be clearly impartial. The judges should acquit themselves as above board, with integrity, and the whole process should be in accordance with the procedures that would not prejudice any of the parties. The proceedings, and generally should be fair. The trial should be fair. The hearing, or whatever goes on, should be fair to all the parties. As we say, the judges are always very concerned that the interests, not when accused before court, is not a lower party. The interests of all the parties in the proceedings are taken seriously. The interest of the accused person, the interest of the victims, the witnesses, and the states, and all other persons. Ensure that is justice. That is why that institution exists, to be able to dispense justice with integrity and above board. And that's why we have judges of integrity chosen through a vetting process that ensures this. Of course, we have human failings, but there are safeguards against that, as we shall see, when it comes to appeal. If, for instance, the judge conducts themselves in a manner that is really, there's misconduct in the whole process that prejudices their own interest, that can form a subject of appeal by any of the parties, if they're able to establish that. Okay, so the accused person has a right of defense, just like most of these rights are replicated rights that are obtained in the domestic jurisdiction. The tenability of the argument that would be advanced, for instance, that the fact that these crimes are serious, they don't need to be really treated fairly, that is questionable and has no basis in law. They deserve maximum representation by the best lawyers possible of their interests, and defended in all these proceedings. So the lawyers they should have a right to have their lawyers, and I'm talking about lawyers who have been listed before the registry as those competent to have, practiced for a number of years, say 10 years, and conversant and able to argue and defend the interests of the parties before the International Criminal Court. Okay, all these proceedings may also take place. They should be afforded. That is, the accused person should have the same way, in a similar respect as he should have a lawyer to defend him, he should also have opportunity to and facilities to his avail to him to be able to research, study, and defend himself and look at the law in order to prepare his defense. He may have a lawyer, yes, but he needs to prepare himself as well. The lawyer will not do everything for him. He needs to be able to, therefore, communicate with all the parties interested. He should have access to his lawyer anytime that he want without any interference from any parties. That is a very important right. And as we know also some of the constitutional rights which are replicated in the international instruments, legal instruments, the trial should proceed in an expedited manner so that any undue dragging or delays would also amount to justice delayed and justice denied. Of course, that's a general very tough, but what I meant to say, if the matter is not expedited and done within, we know in the course of events, the investigations or witnesses and the complexity, these matters may drag long, sometimes up to the point when the accused is in detention until when he gets convicted, he would have already served his time. But that is another issue. And there can be issues of compensation where the accused person is acquitted. Okay, we also said language is critical. It's not about just reading the charges. He may want the proceedings to proceed in a language that he understands very well. The court will make sure that is available. Interpreters who are sworn and accredited will be able to carry out that interpretation. Okay, there's a right of the accused to remain silent. That is very, very critical. You may not have to compel that person to be able to talk in court if they choose not to, or if upon advice. In other words, if there's any confession that is extracted from them, it must be one that is, upon their volition, they voluntarily gave it. Not one where there was duress or some kind of threat or some kind of inducement to be able to confess, like we see in most pariah states carried out by the police. No, this suspect should be afforded the opportunity to freely deny revelation of any information they want to, because that's their right. They could just keep quiet. Or they could plead guilty if they want to. That is their choice. But when it comes to pleading guilty, there are conditions. The judges would have to explain really the implications and be satisfied that they understand the import of that decision that they take, and that the lawyers have been available to explain to them before. Otherwise, it would render a trial to proceed. Okay. So we see that there are quite a number of rights. The other important thing is, just as much as the warrant of arrest and the charges will be revealed to the suspect, it is critical that even the evidence, we know this under the disclosure procedures, pre-trial conferences that we have within municipal jurisdictions, the prosecution should avail all the evidence that they intend to rely on, the evidence that they want to rely on, avail it to the accused person. He has a right to see what, there's nothing like surprise. There shouldn't be any ambush in terms of the trial. So the accused person should avail all this evidence, of course, without necessarily revealing the identity and nature of the witnesses. We shall look at that when you're dealing with witness protection. But the nature of the evidence that the prosecution seeks to rely on should be revealed to the accused so that it helps them in preparing their defense against those charges. All right, so those are critical rights that we need to think about. And the other question that one would ask, of course, I've indicated where this is a very complex process, so that where there is an impecunious state for the accused, where they're indigent, where they're not moneyed, and are not able to afford the services of the lawyer of their choice, then the International Criminal Court under what we look at, the Office of the Public Defender, and we have also Office of the Public. These are independent offices, Office of the Public Witnesses and victims rather. This could provide assistance. They're totally independent, although they operate under the registry. They are totally independent in their operations and not influenced at all by the fact that they're under the ICC. So they could benefit from the services of some of those lawyers without any payment whatsoever, free of charge. Okay, what would happen now once the accused is at The Hague and they're detained in the detention center in Netherlands? And the trial, of course, we know would last perhaps years and years and would be protracted. What rights do the accused have in this instance? They have a right to approach the court, the chambers, and seek to be released pending a trial, finalization of the trial. That's critical. That's the right they have. But now what would happen is that the court would look at the circumstances. They'll be allowed to present their cases to the lawyers individually. And the prosecution would also be allowed to either contest it. And once that is done, the judges would have to satisfy themselves whether this individual could be released in the circumstances. And if they're not released, they still have a right to approach the chamber one more time. And again, usually after about 4 months, if it was declined, they could still approach the chamber with the same request that they be released. Okay, as I just said, we have public counsel offices within the registry. We have the public counsel for the victims and for the defense, which we call OPCD. That's the Office of the Public Counsel. These are
all right.
The witnesses individually as they present. The witnesses in form of proving the guilt. The witnesses.
Thank you very much. That was, if you can hear me, that was
yes,
part of the lecture that I had. Part of it was pre-trial chamber or pre-trial proceedings, and then I went into trial because some of the procedures that are adopted at the trial stage are similar to what we have within the pre-trial stage. But anyway, because of time, I think I would like just to stop there for now. I have more precise points on pre-trial chamber, but I don't think time has allowed it. I just wanted you to have a little glimpse of this particular area, which I've been teaching for some time. Okay, thank you very much, Dr. Marota, and thank you, professors, Professor Dr. Rama, Professor Sripathi, and Councillor Brian Ramapani. I hand you back to Dr. Marota. Thank you. Could you hear me? You can't hear me. Oh.
We can hear you, Professor. We can hear you. I think.
No, we can hear you.
We can hear you, Professor.
We can hear you, sir.
Sorry.
Yeah, we can hear you.
Sorry.
Yeah.
Sorry about that, Hitch. Can you hear me?
Yes, we can hear you.
Can
You
hear
are
you,
very
sir.
clear.
Sorry about that. I just indicated that was part of a lecture I gave, which I normally give, but I tried to combine the two sessions, trial and pre-trial.
Yes.
Yeah, but because some of the points there, I brought it in because some of the points and the procedures under the trial mechanism, the trial chambers are almost similar with what we have in the pre-trial. So that was my presentation for now, and because of time, I hand you over to Dr. Marota. Thank you. Thank you, Prof.
I just have two questions. Thank you. Now I just have two questions as to what Dwarkanath sir has said earlier and listening to your lecture,
Yes,
Professor.
Prof.
Can I just put forth the
Oh, yeah,
question?
yeah. Welcome.
Yeah. Yes. So first question is, what are the special investigative steps that are taken by the prosecutor when the state does not cooperate? Okay, like as Dwarkanath sir has mentioned in his presentation, he said that the special investigative steps are taken by the prosecutor if there is no authorized agency in the state or the state is not cooperating. Right? So what are these special investigative steps? That is one question. And another one that I have is, probably I missed this part. That's the reason I'm just asking you again. And what are the aspects where the single judge and a majority decisions are taken? I mean, what are the differences where single judge decision is sufficient and where the majority decision counts? So what are these aspects? These two I just wanted to have a clarity on.
Okay. Do you want me to take it or somebody wants to take it? Dr. Marota, you want to take that? Or Professor? Or Council? If not, then I'll take it. If anybody wants to take it, it's fine.
Yes, go, Professor. You can start.
All right. With respect to the first question, what investigative steps would the prosecutor take in the event that a state is not cooperating or not willing to be able to cooperate with the court in terms of the prosecution? That would depend on a number of factors. First of all, you'd find that the leadership, the particular political group in power in that particular state, could be the cronies of the suspects, or some of them could be the suspects within the investigation. So that is one of the difficulties, the challenges that the ICC experiences or the prosecutor experiences. Now, when we talk about the state, I tend to think we are talking about the leaders personifying the state as a whole. Because where the state does not cooperate under Article 98 and other articles within the Rome Statute, there's a provision to be able to report such a state to the Security Council or to the ASP, so that the matter is dealt with by the other body of the Assembly of State Parties, ASP, the Assembly of State Parties. Because when you sign and you ratify the Rome Statute, you bind yourself to the provisions of the statute. And now when you're seen not to be able to enforce or to conduct yourself in line with the provisions of the statute, then there's recourse. That is why we have the Assembly of State Parties to have, there's an oversight body, the Bureau, and all this to ensure that the Rome Statute is working. And it is to be upon that assembly to decide on what decision to make. And if it's such a serious matter, it would end up before the Security Council. But now, there could be other means. We have, the question you brought is very important because we have a lot of examples. One of them is Afghanistan, where we didn't have cooperation. When the prosecutor was carrying out the preliminary investigations, although now as we talk, you remember the pretrial chamber authorized the investigations to proceed, which created a lot of hula with the United States and all that. But prior to that, there was a lot of resistance to the prosecutor's attempt to carry out a preliminary investigation and elicit evidence, collect information to be able to approach the pretrial chamber for confirmation of charges. Because you can't just come up with charges unless you have evidence to prove. It's actually some mini trial, although the person brought before the pretrial chamber is not under trial at all. But they'll have a right to defend themselves. They have lawyers to argue that there's no case, there are no reasonable basis to proceed. So it's quite a challenge. And this is a challenge we are facing. It's good that you've identified it. The court is facing this challenge on a daily basis. There are a lot of hurdles placed. We have the Kenyan case where you find the head of state, the person who was supposed to be accused are the head of state now and the vice head of state. And all the witnesses were being harassed, some were killed, others were all over. So those created a lot of hurdles for the prosecutor to proceed. We have a lot of other examples. Rwanda, I mean, all over in cases where we have had the ICC intervene. But then usually the prosecutor will be rendered remediless where there's actually nothing else they could do, because the ICC basically is 100% reliant on, other states to be able to ensure the success of the system. So if this cooperation is not forthcoming, they don't have a police force. There's no international police force that could raid and arrest people. We just had one of the suspects in Kenya the other day just handed himself over, I think 2 days back. You must have seen, if you visit the ICC website. This person was actually supposed to be, he tried to influence the witnesses in a way to defeat the ends of justice. And there was a warrant which was issued for him way back in 2015, I think, yeah? And he only handed himself over the other day. So there are a lot of frustrations that the office of the prosecutor undergoes to ensure that investigations are carried out where the state does not cooperate. And that is why you see the Security Council sometimes steps in. If the dimension of such resistance is of a magnitude that concerns international peace and order, then the Security Council would just refer that state to the ICC. And then when such a referral is made, then the apparatus of the Security Council in terms of enforcement can be invoked to be able to carry out certain activities within the state to assist the prosecutor. That's the difference. That's the only difference where the Security Council pops in. And that's one of the trigger mechanisms through which a case comes before the International Criminal Court. So I think there are a number of other challenges, quite a number. I can't list all of them, but in most cases, the prosecutor has difficulty overcoming them. That's why these cases drag on forever and ever, because the pretrial chamber will not confirm the charges unless there's sufficient evidence to sustain. Right. What was the second question? It was on...
what are the legal aspects, or what are the aspects where single judge decision would be sufficient and the majority?
Yes. As I indicated in my earlier observation, in the pretrial division, we have chambers. Currently, we have 3 chambers within the pretrial division, and the president of the division, there's a president of the division, and there's a president, of course, of the appellate, who is also the president of the entire court. Within the division itself, the president allocates the judges to particular cases. So that will depend on the kind of matter coming before. If it's a question of attending to confirming a warrant of arrest or summons to appear, I think a single judge could work on that. Most of the time, it's just a single judge. But where it's a protracted confirmation of hearing, probably 3 judges. Why? Because of the odd nature, the odd number, so that they will be able to get a majority vote where they don't all, if there's a dissenting judgment, then the other 2 majority could arrive at the judgment of the court, of the chamber for that matter. And so apart from that, we have a number of other functions like Professor Sripathi outlined for the pretrial chamber. So the constitution of the court will entirely depend on the nature, the assignment that's coming before the court. If it's something that one judge can handle, ordinarily one judge could do that. But remember that any decision made at the pretrial chamber is subject to appeal. It could be upheld. So even if 3 judges sit and take a decision, whoever the aggrieved party has the right to appeal to the appellate court, straight away the appellate chambers. That is
appeals chamber.
Yeah, the appeals division. And so it could be attended and the matter reviewed. So in short, the allocation is merely upon the discretion of the president of that division to see that this matter. But in most cases, when the matter, like it is admissibility issue, a matter of admissibility or jurisdiction challenge, where a state is challenging that, for instance, that the ICC has no jurisdiction over that matter, or rather that even the matter is not admissible before the ICC. Most of the time you'd find there are 3 judges, not 1, because it's so protracted and it develops jurisprudence for the court.
Yeah, substantive matter.
Yes, absolutely. Right. Okay, Prof. That is all I could say. Maybe my colleague has something
clear. It's clear. Thank you.
Thank you. So I hand you back to Dr. Marota.
Thank you for your presentation, Professor Milton. Anyone else wants to add something important from what Professor Milton has started?
No, Professor Milton has said it all.
Okay, yes.
Just a
Well,
minute, Brian, what is the question
yes.
you asked? Maybe I did it. What was that question you asked before I started? Councillor Brian?
Yes, I asked a question of the limitations of the pre-trial chamber and of the view that such has been answered by your presentation.
Yeah.
And from presentation from the esteemed Professor Pat.
Absolutely. In fact, even the question presented by Professor Dr. Rama, in a way, was going towards answering that question. Thank you so much. Over to you. Okay, Doc, that was all I wanted to show you.
Yes. Okay. Thank you, Professor Milton, for your add value to this panel discourse. What we need to our viewers is always to check from which country you are, and if your country is part of the RAM statute, to check and read and analyze the part related to international cooperation with the ICC, because that's a very important start point to understand when the ICC through Mutu starts an investigation by its own initiative, or because a complaint arrived to its door. It's very important to see how the cooperation bylaw between the ICC and the country it's integrated, because it will be very interesting to see, to make a study. I will do it related to each country, related to their own law with the cooperation with the ICC, because I guess that at some points the statutes of limitations may differ. It's not like in the Netherlands. The Netherlands, they don't decide it. They use the same cooperation standard that have been done by the ICC. Other countries, they try to adjust. So I will try to do a research about that, and have a chart for discussion. Maybe in 2 months, it will take me to do that chart, so we can see which country I have updated, which one is a little bit behind. So to have, and also it will be very useful to extradition. So maybe from the cooperation with the ICC in the near future, it will help the cooperation that each country has with the ICC. It also will help in the future about the bilateral agreements related to extradition. So we can have one that can hold this system when someone needs to be tried in another country because he committed a crime in the US and he's now in Nigeria, and the US needs to extradite. For example, we can have one through the ICC, to have one treaty to help, because there are some countries that are the paradise for international criminals. For example, for example, the United Kingdom, it does not have many bilateral extradition agreements with other countries. For example, Pinochet with Chile, he couldn't not be extradited to Chile for the crimes that he committed when he was the dictatorship back in the 70s. So, I mean, it's a good start to analyze the cooperation between the countries that are part of the Rome Statute since 2002 beyond, and see the each bilateral agreement between one country and the ICC. In 2007, when I worked with the Andean Commission of Jurists, I was part of an investigation related to that. From Colombia, Ecuador, Peru, Bolivia, Chile, how the agreement of these countries with the ICC is very similar, but we need to see how other countries work. So it will be a very useful tool. Okay, so I pass the floor to Professor Milton, and to if he wants to add something for this meeting, or we just made a call.
Okay, thank you, Doc. That's all for now. Oh, Professor Rama,
Yes.
want to say something?
Yeah, just an addition, Advocate Marota. Just to your extradition point, I just wanted to add, Belgium, it has passed attentat clause, right? If the murder is done with respect to any of the head of the state, or the family members of the head of the state, then they are extradited. Similarly, with respect to if any head of the state has committed any offense and he flew to some other state, then the other states would generally try to protect him and provide asylum to the head of the state if any kind of offense is committed by the head of the state there, and he will generally be not extradited. It's a very good point. I mean, just adding to whatever you have said. Sir, Dwarkanath sir, am I correct? I mean, with respect to extradition.
Immunity.
In fact, under international law, there is a restriction on extradition that
Political offenses
shall not be extradited.
Yeah.
So the head of the state is definitely a political leader. And if he has done any offense, commits any offense in pursuance of his political ideals, then he normally shall not be extradited. Example is the Shah of Iran, when he fled to the US, and when Ayatollah Khomeini came to power, he wanted the Shah to be extradited so that he can be punished in Iran in accordance with Iranian laws. But the United States refused to extradite the Shah of Iran and granted him asylum on US territory. So this is the normal procedure under international law.
Also, we also, as Professor Shipati has told us, it reminds me the case of the Catalonian leader about 2 years ago.
Yes.
He was asyled in Belgium, and then there was a ruling from the European Court of Human Rights. Even though he has the smoking gun related to corruption in Barcelona. I mean, the Spanish court didn't follow the procedure, so, and because he was a leader, he was not possible to extradite him from Belgium to Spain. So what the Spanish decided is to open, I don't remember the convention of the EU related to corruption, and he's right now being trial in Belgium. So yeah, so the idea is that political persons, they always need to have some kind of immunity, because it says that probably the other party are trying to fight against them by, I don't know, intentionally making some phony indictments. However, that is a very thin line, because sometimes they use, for example, as Professor Shibate has told us, other political territory, they're international criminals, and they use that so they can protect us. So there could be, I don't know, a research, a PhD related how to adjust the kind of immunity. For example, in Colombia, the members of the parliament I don't know if it was this year or last year, they have passed a bill so they can reject from their immunity. Only they will have immunity when they are part of a commission that's going to investigate someone. But in other circumstances, they will not have any kind of immunity. So we need to do the check and balance how this will work in the future. For example, using the example of Colombia with high rank politicians. But I don't know. It's a very tricky weapon that can explode on your own face, trying to it's related to
It,
immunity.
it is
Yeah,
interfering
it's
with ICC right, ICC
yes,
procedure, the extradition provided to political offenders. It is interfering with ICC, I think, because ICC cannot exercise jurisdiction on someone who is there
correct.
in
And
the foreign country.
yes,
Okay,
until
And
that's a good
until
point you have introduced. With
yes, until
respect
the
to the
guy needs to.
ICC, with respect to
Yes,
the
Professor.
ICC, there are provisions under the Rome Statute which are very, very clear that no one shall be exempted from any criminal prosecution before the International Criminal Court, either by way, it was so express, no immunity anywhere would bar the ICC from proceeding with the prosecution. That is why you see heads of state being arraigned in there. That's a
Yes.
very contentious provision of the ICC, just as a way of arresting impunity. Right.
but
Yeah,
it
that's
is
the idea.
not necessary that the state where he has flown to, the political offender, if he has flown to India, India is not a party to ICC. So how come
Yeah,
ICC can
No,
exercise
but let me
jurisdiction?
qualify that. That's a good question. I'm talking about ICC where, just because you mentioned ICC, only where the crimes committed are those within the jurisdiction of the ICC. When that particular leader is suspected of having committed, if he's running away from his own country and some of the crimes is committed there, according to the pretrial chamber, they have concluded that there are confirmation of charges. They can confirm actually that investigation should proceed on the basis of those crimes. Then he could be pursued regardless of where he's gone. Actually,
yes,
the person, the subject matter here would be the person, not even the host, where is hiding for his is gone on asylum. Whether the host is a state party or not would be immaterial, because the ICC would go against the jurisdiction would be over the individual. If that particular, so we look at whether that individual is a national of a state party to the ICC. If he was a state, an individual citizen or a national of India that is not actually a state party, there are other issues to be considered.
yes, and also,
Yeah.
yeah, that's correct what Professor Milton has said. And also, in this case, he will have a red flag from Interpol, and Interpol will aid. So they will start to use all the bilateral agreements related to extradition. I mean, as Professor says, it's over the person that have the jurisdiction. So they will do all, the ICC will do all his maneuvers to extradite this person.
Yes, but that immunity is actually applicable in other jurisdictions where it,
Correct.
yeah. But as far as the ICC is concerned, it is so clear. I think it's article, I'll be able to provide that next time. That article simply provides that there is no person who shall be barred. The ICC shall not be barred to prosecute or anybody by virtue of immunity. It's so clear. And that is why you see all these presidents who have been abusing their positions. Some of them have been arraigned before court, the ICC.
Yep.
That was an interesting question.
The ICC also says,
yeah.
The ICC also says that when a person commits an offense on the territory of his state and then flees to another country, that is a third state, a third party.
Mm.
The third party is a party to the Rome Statute. There is an obligation on the part of that state to surrender to the ICC.
Exactly. Absolutely. And where that party fails to surrender, like we had the case of Omar Bashir going to all the African countries, South Africa here, they went to just trying to show that he
traveled all over Africa.
Those people could be reported to the ASP, and eventually the Security Council could step in.
Yes, yes.
Those are very interesting points, actually. All right. I think if there's nothing more, our time is up now. It was a
Yes.
pleasure having the professors today. I hope you viewers have really enjoyed the discourse and you've seen how brilliant the professors are, how they're able to, have a discourse over a number of facets of the topics we're discussing. I'm very, very grateful to Professor Dr. Rama Gudumela, Professor Dr. Sripathi Dwarakanath, Dr. Vani Marota, and Council Brian Ramapani for your presence. It was a pleasure having you with me today. And thank you all viewers, wherever you are in the world. Thank you for being patient with us and being together with us. We hope to see you again in the next 2 weeks. All our sessions shall be on Saturdays when all the other professors can also join us. Bye-bye for now.
Bye.
Bye.
Thank you. Have a nice